Welcome to a joint webinar on Trademark Registration and Protection in China, Pitfalls and Solutions. My name is Somboon Tilasalan, a partner at Tilleke Gibbins International, and I will be your speaker and moderators of the event today. And for our participant from Thailand, สวัสดีครับ ขอต้อนรับทุกท่านเข้าสู่งานสัมมนาการจดทะเบียนและการคุ้มครองเครื่องหมายการค้าในประเทศจีน อุปสรรคและทางออกโดยผมสมบูรณ์ธีรสลันผู้หุ้นส่วนสำนักงานเทเลกี้จะรับหน้าที่เป็นผู้ดำเนินรายการในวันนี้นะครับโดยในการบรรยายในวันนี้จะเป็นการบรรยายภาษาอังกฤษและมีคำบรรยายภาษาไทยนะครับและหากท่านใดมีคำถามท่านสามารถพิมพ์คำถามทั้งภาษาไทยและภาษาอังกฤษได้ในช่อง Q&A นะครับหรือ Chat Box นะครับ This webinar today is a joint collaboration between Tilleke Gibbins, a regional law firms in Southeast Asia, CCPIT, the oldest IP firms in China, and International Trademark Association, or INTA. First and foremost, on behalf of Tilleke Gibbins, we would like to express our sincere thanks to our co-hosting partners, all speakers from CCPIT, for your contribution and knowledge sharing, and to INTA for accepting to include this session in its International Education Roundtable project. This webinar is in fact a result of our active listening to our clients as we held a webinar on US trademark registration back in March 2021, which I believe that many of you have attended. And from our survey after the event, many respondents had replied that they wanted to hear a similar topic, but for China this time. This aligns with the fact that at Tilleke Gibbins, among all our overseas cases that we represent our clients, we found the most outgoing application to China. Thus, we believe that the webinar will be very useful for all brand owners. And next, to kick off this webinar, I would like to share a welcoming remarks delivered by Mr. Xuan Honglong, the president of CCPIT. The video, please.
Hello, ladies and gentlemen. Welcome to the INTA webinar. I'm Chuan Honglong, President of CCPIT Patent and Trademark Law Office in China. First of all, on behalf of CCPIT Patent and Trademark Law Office, I wish to extend my gratitude and thanks to all the speakers, moderators, coordinators, as well as those who have put extensive effort, time, and dedication in preparing for this webinar. Moreover, I profoundly thank the team of Tilleke and Gibbins for our excellent cooperation. Notably, I would like to earnestly thank INTA for providing a platform and promoting our webinar to INTA members regionally under the International Education Roundtable project. The title of this webinar is Trademark Registration and Protection in China, Pitfalls and Solutions. Nowadays, China attaches greater importance to brand building and IPR protection. Trademark is the main manifestation of a brand and an important category of intellectual property rights. With the development of economic globalization, trademark is no longer a regional concept. China welcomes the cooperation with more countries and regions. I hope that through this webinar, you will have a better understanding of the trademark registration and protection in China. As one of the leading full-service intellectual property law firms in China with the longest history, our firm has not only witnessed the development of intellectual property legal system in China, but also made tremendous contributions to the creation, protection, and utilization of the intellectual property rights in China. Building on our professional standards and core values, our firm has been the mainstay of China's intellectual property legal service community for more than 6 decades. We are very happy and willing to take this responsibility of introducing and analyzing the current practice of trademark registration and protection in China to the world. Finally, I once again warmly welcome each one of you. I believe that the webinar will be successful and productive. Thank you.
Okay. Next, I would like to invite Ms. Dharani Wajanavutivong to deliver her welcoming remarks on behalf of INTA. Ms. Dharani is our co-managing partner of Tilleke Gibbins and also a co-chair of Asia Pacific Global Advisory Council, or known as GAC of INTA. So Ms. Dharani, over to you.
Thank you very much, Mr. Somboon, and Sawadika. And good afternoon, Mr. Chun Hong Long, President of CCPIT, Ms. Ling Zhao, Ms. Yali, Ms. Xiao Ping Wai, Ms. Lai Fu, and all participants. On behalf of International Trademark Association, or INTA, I would like to welcome all participants to this very interesting webinar, where we will learn all about trademark registration, prosecution, domain name, custom, and enforcement in China in one seminar. Participants who are from corporations may not familiar with the name INTA. INTA is a global non-profit advocacy association of brand owners and professionals dedicated to support trademarks and related intellectual property matters, to foster trademarks and to foster customer trust and economic growth and innovation. INTA's members are from more than 7,200 organizations from 187 different countries. Despite the impact of COVID-19, INTA has organized over 200 meetings and virtual delegations, more than 100 submissions and testimonies, creation of number of studies. So I wish to recommend participants consider becoming member of INTA to learn more about interesting IP topics, global updates and trends. Many thanks to CCPIT and Tilleke Gibbins for co-hosting this webinar, and wish to congratulate on the success of this webinar. Wish you all enjoy the webinar. Thank you very much.
Thank you very much, Ms. Dharani. And next, without further ado, let me share my screens to walk you through the webinar today. So the title of today is Trademark Registration and Protection in China, Pitfalls and Solutions. So as many of you know, and I believe that this is part of the reason why you all are here to listen to this webinar, because we have seen a tremendous number of filings of trademark in China, and nobody can refuse the fact that China is becoming #1 in both receiving countries and outgoing filers in the world trademark prosecution. So if we look at the fact, in 2019, 7.9 million trademark applications were filed in China. This includes both domestic and international trademark filers. And despite the pandemic in 2020, there has been 20% increase in the number of filing of trademark applications in China. And as you can see, the trends even stronger despite the pandemic. So this is clearly showing that trademark filings is pandemic proof and crisis proven activities. And these are some of the common issues facing the brand owner, despite the fact that China has been receiving a huge number of applications. There are still a lot of things that our colleagues from CCPIT will walk you through today, how to address each of the questions here. So first, China has quite a unique trademark examination criteria. So despite the fact that China has adopted NIST classification, they have their own local subclass, which is part of the criteria in determining similarity between the marks. And as I showed you in the previous slide, there has been a huge number of trademark applications in China, which would resulting in more possibilities of confused trademarks to be rejected. And just to give you some idea, many of you who are residing in Southeast Asia, each of our countries would see around 40,000, 50,000 applications a year, which means even though for Thailand, let's take Thailand for example, if we found 50,000 applications a year, for 100 years, it will become only 5 million applications altogether, which means even with 100-year combined of number of applications, it does not match with the number of applications in China, only 1 year. So that's just to give you some idea of how huge is the number. And then many of you who have experienced prosecuting in China, you will see that there has been a short deadline to file a review with the CNIPA, simply because the process of trademark examination in China has been very, very fast, and it's becoming faster as years goes by. And because of the huge number of applications, obviously, inevitably, this will result in some bad faith application and registration, which many brand owners might have faced in China. And our colleagues at CCPIT would then give you some idea how to tackle that issue. And then another unique characteristic of China prosecution is that non-use cancellation, which any brand owners can file with for any trademark registration that has been registered for the past 3 years. But in China, the burden of proof would be lie on the trademark registrant themselves. So if you are trademark owners, you have to make sure that you will be able to use the marks in China within the next 3 years. Otherwise, there will be some risk of losing non-use cancellation as well. Another issue that many brand owners might be facing lately is the illicit emails. We have to admit to the fact that there are some illegitimate reach out by some smaller Chinese firms in China. Obviously, they would try to reach out to CEO or directors of the company, which in many cases will spark some dismay among the legal team. So again, we will discuss how to address this issue. Next, we are going to look into the enforcement measures available to trademark owners in China. And lastly, we also would looking at how to tackle the domain name dispute. Let me introduce to you our 4 speakers today from CCPIT. First, Ms. Ling Zhao. She's currently a Deputy Director of International Trademark Department of CCPIT. She obtained her Master in Law in Intellectual Properties from School of Renmin Universities in China. And most notably, she was awarded as Trademark Attorney of the Year by China Trademark Association. And she has been ranked top 50 China IP lawyers in 2020. So you can really count on her years of experience in this area. Our next speaker is Ms. Ji Li. She has joined the firm in 2012. She obtained her master's degrees from Beihang universities, and she has been tackling a lot of trademark prosecution issues on a day-to-day basis. And based on my personal experience, I can assure to you that Ms. Ji has a lot of experience in this area where she can really contribute to this speaking session today. Next, Ms. Xiaoping Wei. She joined the firm since 2008. She obtained Master of Law from Law School of Renmin Universities in China. And she has been working both on trademark prosecution side of it, as well as some administrative protection of trademark rights, as well as other legal service for the firms. And she has been recognized by most multinationals investing in China. And lastly, Ms. Lei Fu. She's a qualified trademark attorney joining the firms in 2003. and she focused on IP infringement and unfair competition, which is another areas of work that has been very, very in huge demand in China. Again, without further ado, let me share the videos of presentations today, which it will be delivered in English, but it has Thai subtitle for the sake of our Thai registrants today. Thank you.
The creation, utilization, and protection of intellectual properties is indispensable for economic and social development. As the IP law firm with the longest history in China, CCPIT Patent and Trademark Law Office embodies the spirit of enriching your ideas from the beginning. In the course of 6 decades of development, the firm has provided services for tens of thousands of clients spanning all industries with professional skill and efficient management.
China has witnessed continuous growth of trademark filings in the past few years. The number of trademark applications by both domestic and foreign applicants in the year 2020 has reached over 9 million. We now have a very large pool of registered trademarks, which is over 34 million in total. Just imagine, faced with such a large number of valid registrations, the trademark applicants might easily encounter apply similar trademarks composed of similar devices, letters, or characters. How to overcome those prior citations and official refusals? Any pitfalls in the process of trademark registration that foreign applicants need to be mindful of? China adopts a subclass system to determine similarity of goods and services, which makes examination efficient and transparent. Well-known trademarks enjoy cross-class protection, which helps to widen the scope of protection of our trademarks and increases our success rates in oppositions, invalidation actions, and civil disputes. What strategies should we take to best enforce and protect our trademark rights in China against infringements? In the following 1 hour, we are going to share with you our insights and observations about these interesting topics. But before we start, let me take a brief introduction about the speakers here today. My name is Ling Zhao. I'm Deputy Director of the International Trademark Department of CCPIT Patent and Trademark Law Office. I joined the firm in the year 2000, and I have been practicing trademark law for over 20 years. I'm experienced in both trademark prosecution and litigation. Here with me is Ms. Tilleke. She is also a senior trademark attorney of our firm, who joined the firm in the year 2012. Today, she's going to discuss about the subclass system, similarity of trademarks, and strategies to overcome official refusals. So China adopts subclass system to determine similarity of goods and services. However, many of our foreign applicants are not very familiar with the system and often encounter some problems in the process of trademark application. Could you please describe how the system works?
Okay. China adopts the niche class system, which is composed of 45 classes of goods and services. Briefly, the goods belong to class 1 to class 34, and the services belong to class 35 to class 45. China further follows a subclass system in which each subclasses in each class work independently. The subclasses are determined based on the similarity of goods in respect of functions, uses, raw materials, sale channels, consumers, etc., and similarity of services in respect of purposes, contents, methods, consumers, and so on.
Can you give us some examples?
Sure. Class 7 has the largest number of subclasses, 54 subclasses in total. You can see the machinery for agriculture and the machinery for fishery and animal husbandry belong to different subclasses because their functions and the industrial uses are different. Another example, class 25 has 13 subclasses in total.
So what's the purpose and significance of the subclass system?
On one hand, the subclass system can help to determine the scope of protection of goods and services. According to the CNIPA's latest practice, only the standard goods and services can be accepted by the CNIPA. Those in the Chinese classification of goods and services and in a list of the supplementary list of other acceptable items issued and updated by the CNIPA can be considered as standard goods. A trademark owner enjoys the right in the covered subclasses. However, almost no rights in other uncovered subclass. Taking the class 25 as an example, choosing goods in subclass 1 of the class 25 will not cover the goods in subclass 10 of the same class. On the other hand, the subclass system can also help to determine the similarity of goods and services.
Yes, the subclass system is very useful for the examiners to determine similarity of goods and services. Just take class 25, for example. So that means the clothing and shoes are actually not similar goods because they belong to different subclasses, right?
Yes.
Can we use class headings to cover the whole class?
Oh, the answer is no. We know each class has a class heading. The class heading usually indicates the scope of goods and services within that class. Usually, the class heading are too general to be accepted by the CNIPA. However, even if they are accepted, only the item described can be covered, rather than the whole class. Taking the class 25 as an example, the class heading for class 25 is clothing, footwear, handgear. The registration of your mark on such class heading cannot cover the whole 13 subclasses. The item clothing covers the subclasses 1 to 5. The item footwear covers the subclass 7, and the item handgear covers the subclass 8. However, the other subclasses 9 to 13 are not covered. That is to say, for class 25, the class heading cannot cover the whole class. Under this circumstance, there might also a potential problem. You thought you had covered the whole class. In fact, it is not true. The other party can still register your mark in the uncovered subclasses. So if you want to cover the whole class, our suggestion is to choose at least one standard item of goods and services from each subclass.
So in some official refusals, we noticed that the slightly marks actually coexist with each other, although they are quite similar to each other in the same class, while our application just gets rejected. How does that happen?
Oh, this is a very common issue. The subclass is often neglected. Normally, the slightly mark can coexist because their goods and services belong to different subclasses, so they would be deemed as dissimilar goods. our suggestion is to we can also take advantage of the subclass system. When you receive a notification of refusal and there are too many citing marks, you can simply focus on the key subclass of your main interest to reduce the number of the citing marks. That would improve the chance of success of the registration of your own mark.
Okay, that's a good point. Another question. We have a famous brand, but we found that some other parties, they register very similar or identical trademarks in on relevant goods and services in different classes or even in different subclasses. How do we prevent such things to happen?
For your key marks, we suggest carefully preparing your list of goods and services before the new trademark filings in China and paying high attention to subclasses. If you want to enjoy broader protection in one class, you should cover all the subclasses or as many relevant subclasses as possible. In addition, if budget permits, we also suggest covering class and subclass that your business may expand. Therefore, it is very essential to establish your own trademark portfolio as soon and as broad as possible. By doing so, we can leave no holes for trademark squatters.
Given the importance of the subclass system, we do need to use standard descriptions of goods and services when we find a new application so that our client institute items can be sufficiently covered in the proper subclasses. So having discussed about the similarity of goods and services, we now come to another fundamental issue in our daily trademark prosecution, the similarity of trademarks. What are the most basic criteria of the CNIPA in determining the similarity of trademarks? Any major factors to consider?
Yes, to determine similar marks in the trademark registration procedure, first we need to determine whether the goods and services are similar. Second, we need to determine whether the marks are similar. To do so, two main factors should be taken into consideration. The first one is to determine similarity of marks in appearance, pronunciation, meaning, overall expression. And the second one is to conduct overall comparison and comparison of the main part under the isolated observation based on the general attention of the relevant public. In the other procedures, such as oppositions and invalidations, we should also consider other factors like the distinctiveness of the prior mark, the reputation of the prior mark, a likelihood of confusion among the consumers as to the origin of goods and services.
Can you give us some examples, case studies, to better understand the criteria in different procedures you just mentioned?
Sure. First, I will show you a refusal review case. The applied mark is composed of 4 letters, ROOM, in an irregular order. The citing mark both contains the word rule. The goods covered by the applied mark and the citing marks belong to constitute similar goods. In the decision on the refusal review, the CNIPA holds that the applied mark and the citing mark are similar in respect of the letter combination, pronunciation, and meaning. However, in the litigation procedure, the court overruled the CNIPA's decision and held although the applied mark and the citing mark contain the same word rule, the 4 letters of the applied mark are arranged in an irregular order. So the applied mark and the citing mark can be distinguished in respect of the appearance and visual effects.
It's interesting to see that a Latin trademark, which is sufficiently stylized, it could look so different from the block letters. So I think it's correct to decide in this case that there's no likelihood of confusion. But will use and reputation of the trademarks involved be taken into consideration in the procedures of review of refusal?
Oh no, usually in the refusal review case, the use and reputation of the marks will not be taken into consideration. That is because the citing mark owner does not participate in the refusal review case. It would be unfair to the citing mark owner if only the use and reputation of the applied mark is taken into consideration.
Yes, that makes sense. How about the similarity of marks decided in oppositions and invalidation action cases? Any other factors to be considered other than only the appearance, sound, and the meanings of the marks per se?
Yes, in the opposition or invalidation cases, we should also consider other factors. Here I will show you another case, an invalidation case. The disputed mark is composed of 3 Chinese characters, 海蓝富, and the Chinese corresponding pinyin. And the citing marks 224 is composed of 3 Chinese characters, 格兰富. The last 2 Chinese characters of the disputed mark and the citing marks 224 are identical. However, the first Chinese characters is different. Normally, marks with different initial Chinese characters may be considered as dissimilar mark. However, in this case, the court took the reputation and the distinctiveness of the citing marks into consideration and held the disputed mark and the citing marks 224 constitute similar marks. Regarding the citing mark 1, the court also held that through extensive use and publicity, the citing mark 1 ground false and the citing mark 224 have established one-to-one correspondence in the Chinese market. So the court further determined that the disputed mark and the citing mark 1 constitutes similar marks.
Well, it's interesting to notice that the English letter trademarks can be considered similar to Chinese character trademarks, although there's no direct link in their meanings. But as you said, the citing mark ground false English letters has been used together with the Chinese characters mark 格兰富 for a long time, and they have established corresponding relationship with each other. Now, after talking about the fundamental issue of similarity, we'd like to offer some practical strategies to overcome official refusals. By the end of the year 2020, the total number of valid registrations in China is more than 30 million in total. So a straightforward registration might be very difficult.
Yes.
After filing a new trademark application in China, applicants might encounter a provisional refusal due to both absolute grounds and relative grounds. But in practice, we encounter more relative grounds than absolute grounds.
Yes.
So that's to say, we'll easily encounter a prior citation. For such kind of refusal, what strategies would you like to suggest, recommend our foreign applicants to follow?
Yes, we do have some recommendations. First, it is the most commonly used strategy. Strongly argue the dissimilarity of the marks and strongly argue the dissimilarity of the goods and services. Second, file a non-use cancellation against the citing mark if it has been registered for more than 3 years. Third, file an opposition or invalidation action against the citing mark if the applicant has prior use of their mark in mainland China, or the citing mark owner has obvious bad faith. Fourth, try to obtain a letter of consent from the citing mark owner.
So we believe it's fair to say that if the two marks are not identical and have certain difference, it will be worthwhile to try with a letter of consent, especially when owners of the two marks are actually involved in different business and actually has no commercial conflict at all.
However, if the applied mark is identical or highly similar to the applied mark, we are afraid the letter of consent will not be accepted. We should also remember that if the citing mark owner is a Chinese company, an original or notarized letter of consent with the company seal is needed. While if the citing mark owner is a foreign company, the letter of consent should be notarized and legalized. Last, our recommendation is to try acquire the citing mark.
So, yes, although the straightforward registration is not so easy in China now, what we will recommend that a client to try the review of refusal actively?
Yes. We still suggest the client to try the review on refusal actively by strongly arguing the dissimilarity of the marks, dissimilarity of the goods, and in the meantime, taking actions against the citing marks.
So as that, China is the first to file country, so the seniority lies with the trademark with the earlier filing dates. But in case two applicants or more applicants happen to file the identical trademarks on the same day, how do we decide about the seniority?
When encountering this situation, the applicant may follow the following 3 steps. Step 1, both parties are required to submit use evidence indicating the first use of their mark. The use evidence should satisfy some requirements. First, the use evidence should be formed before the filing date of the mark. Second, the mark should be used in mainland China. Third, the mark should be used on the designated goods and services. Finally, the use evidence should be in original or notarized ones. However, if the evidence submitted by the two parties is not effective, or no evidence was submitted before the CNIPA, both parties will go into step 2, negotiation. After negotiation, only one party can maintain this application.
But in case negotiation fails, what happens then?
Then we will have to enter into the step 3, drawing laws. We have to say the result of the drawing of laws is determined by fortune. Currently, the drawing of laws is conducted offline and online. In our opinion, the online way is faster and more efficient. Here, I will briefly introduce how the drawing of laws is conducted online. Both parties register an online account and upload the basic information into the system. After data review, both parties begin to drawing laws. The drawees was asked to choose one card of each of the 3 groups, ones, tens, hundreds. After the drawing of the laws is completed, the system will announce the result. The party with a larger number of points will win.
Okay. Does it mean that by winning the drawing laws, we are going to get a trademark registration?
Oh, unfortunately, no. The application will still go into the substantive examination and may encounter provisional refusal, if any.
So finally, any takeaways for our foreign applicants in order to get a trademark registration successfully in China?
Yes, we do have some suggestions. First, since China is our first to file country, so it is advised to filing new trademark applications in China before you plan to develop and go and enter the Chinese market. Second, claiming priority right in other countries, if any, when you file new trademark applications in China, so as to obtain an early filing date. Last, you can keep the use evidence properly if you have used your applied mark in mainland China.
is Xiaoping Wei. She is also a senior trademark attorney of our firm. She joined the firm in the year 2008. She has practiced China trademark law for over 10 years. Today, she is going to discuss about any common pitfalls in the process of trademark registration, and we're going to share some interesting cases about well-known trademark protection and bad faith trademark filings in China. So as an experienced trademark attorney, any common pitfalls we would like to remind our foreign applicants to pay attention to, and any suggestions to avoid such pitfalls in order to get their trademark registration successfully in China? For example, apart from the relevant grounds, such as citations of prior trademarks, we sometimes also encounter absolute grounds of refusal, like a deceptive trademark, which is not allowed to be registered according to Article 10 of China trademark law. We would like to share some examples on this issue.
Wow, there are many two reasons that the CNIPA refuse a trademark based on grounds of deceptive. One is that the trademark or the element in the trademark is misleading as to the quality, function, raw materials of the goods or services. And the other is that the trademark or the element in the trademark is misleading as to the origins of the goods or services. Here are two examples to show how the authorities examine whether a trademark is deceptive. The first case is regarding trademark Indo-Creamer, which covers goods in class 30. The CNIPA refused trademark based on the grounds that the trademark can be understood as creamer from India. So when used on the designated goods, it is likely to mislead consumers as to the origins of the goods. We filed a review by arguing that the trademark is not deceptive. We filed information for the applicant's registration of the similar trademark Indo-Creamer in China, which also contains Indo, and also copies of registration certificates for the applicant's same trademark Indo-Creamer in other jurisdictions. Upon examination, the CNIPA holds that the Indo in the trademark has no fixed meaning and it has no direct association with India. So creamer in the trademark is also not deceptive as to the origins of the goods. So the mark can be considered as not deceptive.
I think this is a really lucky case. How about the other one?
Well, let's see the second example case, which was ruled recently, but it was not so lucky. The second trademark is regarding crown cheese. It also covers goods in class 30. Among the designated goods, it covers cheesecake, cheese flavored biscuit, and cheeseburger with contained cheese. The CNIPA refused the mark on all the designated goods on the grounds that it is deceptive as to the goods and shall not be used as a trademark. Though we argued that the mark is not deceptive because it can be considered as a whole and shall not be divided randomly, we argued that the mark has been put into wide use in China and no misleading was caused. And we also argued that at least the mark shall be registered on the goods that contain cheese. But it is regret that both the CNIPA and the first instance court made unfavorable decision to us. At present, the case is pending in second instance litigation, and we hope that the mark can at least be protected on the goods containing cheese.
I think the examination criteria on such refusal grounds is really strict now.
Yes, based on our experience, we do have the feeling that in recent years, the examiners adopt a relatively strict examination standard regarding the refusal ground of deceptive. And if a trademark is refused based on the grounds of deceptive, it is usually not easy to overcome.
Yes, I agree. In case our trademark gets refused due to this refusal ground, it will not be easy to overcome the refusal. So what kind of a suggestion would you like to offer for our client to avoid such refusal?
Yeah, here are our suggestions. First, to discuss with your local trademark representative regarding the possible risk of refusal based on deceptive before filing. Second, if possible, adding other elements into the trademark or modifying the goods or services description so as to eliminate the possible risk of a refusal based on grounds of deceptive. Third, if a mark is refused and a review is filed, actively defending by evidence such as registration certificates of the trademark of similar nature in China, registration of the same mark in other jurisdictions. And if the trademark has been put into widely use in China, we also suggest filing evidence to show that there was no misleading cost. Even though if a trademark has been put into use or not, it's not a factor to be considered whether a trademark is deceptive or not.
China is a member of a MAGIL system. In the year 2020, the CNIPA has received over more than 24,000 MAGIL international registrations filed by foreign applicants designating in China. So national applications versus MAGIL international registrations, which approach has more advantages for the trademark applicants?
In our opinion, we suggest filing national trademark application for international marks. The CNIPA will not issue registration certificate. So to enforce your trademark rights, you need to apply a certified copy of registration certificate, which needs additional time and costs. Besides, the goods and the services description for international marks are literally translated by the CNIPA, so it may not correctly cover the applicant's interests or fall into the correct subclass, which is essential to determine the examination scope of your trademark and determine the similarity of the goods with other marks. What's more, it takes around only 4 to 6 months for examination of national trademark application, which is much less than that for international marks.
So we would suggest filing national applications instead of MAGIL international registration designating into China. So how about multi-class application? Is multi-class application available in China now? And compare with to single class application, which one do you recommend?
Well, multi-class application is acceptable in China, but China is a newcomer to the multi-class application, so there's some drawbacks. For multi-class application, a divisional application can only be filed after the mark is partially refused. So if there's office action, if there's opposition, or even non-acceptance against one class of the multi-class application, the registration process for the whole classes will be influenced. And what's more, if the applicant of multi-class application wants to assign one class of the mark to other parties, he needs to assign the mark in all classes. Lastly, the official fee for multi-class application is still charged per class, so there's no cost advantage.
Yes, so we also suggest filing single class applications instead of multi-class ones. You have talked about some common pitfalls in the process of trademark applications. How about any pitfalls regarding the use of trademark in China? You know, China is branded as factory of the world, which means we have a very important foreign trade mode that is OEM, meaning original equipment manufacturer. The use of a trademark on OEM products qualify as effective trademark use to defend our trademark registration against non-use cancellation. How the OEM trademark use evaluated in the civil litigation against infringements?
There are several situations to be considered in determining whether the use on OEM products can be considered as effective use. First, in-use cancellation. At present, the use of a trademark on OEM products which are manufactured in China and are exported to foreign countries can still be considered as valid use to maintain a registration in-use cancellation procedure. Second, in opposition and invalidation procedure. When we talk about trademark use, we usually mean the actual sales of the products in the Chinese market so that the reputation can be built up through the long-term use of the trademark. But the use of a trademark on OEM mode is kind of a closed circle use, so it is hard to build up a reputation through such way of trademark use. Third is in trademark infringement. To determine trademark infringement, we need to consider if there's likelihood of confusion among the Chinese consumers. In the past, the use of a trademark on OEM products was not considered as a trademark infringement because there's no circulation of the products among Chinese consumers. But in a recent infringement case, Honda versus Honda Kate, the Supreme People's Court of China confirmed that OEM shall not be simply exempted from the trademark infringement. We have to analyze case by case.
Indeed, the Honda Key case has caused a lot of public attention because this is a landmark case made by the Supreme People's Court of China regarding OEM trademark use. So in this verdict, the SPC confirmed that OEM trademark use is a kind of effective trademark use to qualify to defend our trademark registration against non-use cancellation. Lately, many foreign clients they have been approached in an ethical manner by Chinese firms who informed them that their trademark application got refused by the CNIPA even before their entrusted trademark agents received the official refusal notifications. How does this happen?
Well, indeed, illicit emails are really annoying not only to the applicant, but also to the trademark agency, foreign or local. There's fierce competition among the Chinese representatives, and I think such unsolicited contact should be considered as an unfair competition. The companies get the information through an illegal source. So if you receive such kind of emails, please just disregard and make no response to them. The good news is that the CNIPA just published a draft for measures to tackle with this situation. The CNIPA will establish blacklist published to society in a certain term, accept social supervision, and take collaborative constraint measures. Though at present, it is still a draft for comments. We believe the market order of patent trademark representative industry and fair competition environment will be better improved and protected.
Yes, the CNIPA is actually determined to tackle the illegal collaboration between officials and trademark agents. So ignoring those illicit emails is the best solution for our client to avoid any unnecessary trouble. So foreign clients are actually very interested in well-known trademark protection in China. Could you please give us some brief idea about this topic?
For a registered trademark, the claim for well-known recognition and protection will not be granted by the authorities unless it is cross-class protection over dissimilar goods and services. And the recognition of well-known trademark is case by case on the demand of trademark right owner.
So we would like to say that well-known trademark protection in China is kind of a passive protection.
Yes.
We need to claim for the protection. Would you like to share with some interesting case study?
Here are two invalidation cases that we just received favorable decisions from the second instance court. The two disputed trademarks are both composed of 4 Chinese characters, 劳师来师. The covers goods in class 6 and class 19 respectively. The cited mark is also composed of 4 Chinese characters, 劳斯莱斯, which is known as Rolls-Royce in Chinese, which is widely known to the public on automobiles in class 12. The court confirmed the well-known status of Rolls-Royce in Chinese in class 12 and gave cross-class protection over dissimilar goods in class 6 and class 19.
So what are the main factors the court will consider to determine the well-known trademark status?
There are several factors to be taken into consideration when determining if a trademark is well-known. First, the popularity degree of the trademark in its trading area. Second, the duration of the mark that has been in use. Third, the duration, extent, geographical range of advertising or publishing of the trademark in Chinese mainland. Fourth, the records of protection as a trademark. And fifth, other reasons that to be considered to show the reputation of the trademark.
Is it necessary to satisfy all those factors to get well-known trademark recognition?
No, it is not necessary that a well-known trademark shall fulfill all the above-mentioned factors. The most important factor to be considered is the reputation degree of the trademark in its trading area. In this case, the sales volume of Rolls-Royce in Chinese automobiles is limited, and the advertising of Rolls-Royce automobiles limited, but authorities still consider the well-known status of Rolls-Royce on automobiles based on the reputation degree of the trademark in Chinese market.
Okay. What kind of evidence we can submit to prove our well-known trademark status?
Well, to prove the well-known status of a trademark, we need to file evidence to show the continuous use of the trademark that formed 3 or 5 years before the application date of the disputed mark. And we need to file evidence to show the reputation of the mark and the ranking of the company in the relevant industry. Supporting evidence includes, but not limited to, advertising materials, trading documents such as contract, delivery notes, invoices, etc., which can correspond to each other. Materials to show the attending of exhibitions, honors, or awards that obtained by the trademark.
So based on your experience, do you say that it's easy to get a well-known trademark recognition?
Well, based on our experience, we have to say that it is not easy to recognize a well-known trademark, and usually abundant evidence will be needed.
Okay. So once recognized as well-known trademarks, does it mean that our famous brand will enjoy protection in the whole 35 classes? Or if not, is there any boundary of the protection scope of a well-known trademark? How to decide about the protection scope?
The scope of protection of a well-known trademark shall be conformable to the reputation degree of the well-known trademark. In this case, because the trademark Rolls-Royce in Chinese enjoy very high reputation and is widely known to the public, so it can enjoy a wider cross-class protection.
Our firm has actually successfully helped our clients to recognize many well-known trademarks. And I think it's good to know that China's well-known trademark protection system is actually very efficient. So we do hope that we can have our clients more well-known trademark recognized so that they get better protection in China. China is taking actions against bad faith trademark filings. Article 44 of the China trademark law is frequently used by the CNIPA to invalidate bad faith trademark registration. We would like to share with us some interesting case about this topic.
Well, Paragraph 1 of Article 44 of the China trademark law usually applies to the situation where the disputed party filed numerous trademarks that shall belong to others. Here is an example that we handled. The disputed mark is Daweiwa, covers goods in Class 3. The registrant of this trademark is a Chinese company called Baoding Zhongmiao Company Limited. Here's part of the trademarks that filed by the registrant. As you can see, the registrant filed many trademarks which shall belong to other companies, mainly from Thailand, in cosmetic, mosquito repelling, and laundry area. Based on the fact of mass holding, the CNIPA holds that such behavior exceeds the normal business needs and disrupts the management order of trademark registration. So the trademark was invalidated based on the Paragraph 1 of Article 44 of the China trademark law.
In addition, The Article 4 of the newly implemented China trademark law also regulates that benefits trademark applications that is not intended for use should also be rejected. The CNIPA also adopts a special regulation to tackle benefits trademark filings in the year 2019. So, according to this article, any trademark agencies representing benefits trademark applicants should also be sanctioned. So we believe that the CNIPA and Chinese authorities are determined to tackle down benefits trademark filings in China. So Ms. Fu Lei, she's a senior trademark attorney of our firm who joined the firm in the year 2006. She's an experienced and devoted trademark attorney with our enforcement team. Today, she's going to share her insights about the trademark enforcement in China, including both litigation and non-litigation approaches. We have discussed about the subclass system and common pitfalls in the process of trademark registration. Now, after getting our trademark registered successfully in China, how do we best enforce our trademark rights? Can registered trademarks and unregistered trademarks be protected with the same degree in China?
Well, the answer to this question is no. The protection on registered trademarks and unregistered trademarks are quite different. According to China trademark law, the owners of registered trademarks have exclusive right, while unregistered trademarks are only protected under very limited circumstances, such as that it reached the well-known status based on years of prior use in China. Therefore, we suggest our clients file trademark application for registration in time in order to obtain adequate protection in China.
So, what actions can a trademark owner take against trademark infringement in China?
The trademark owner could file a civil litigation in court or file a complaint with local competent administrations when trademark infringement dispute arises. Besides the legal actions, if trademark owner find minor infringement in China, they could deliver a cease and desist letter to the suspected infringer. For infringement found on online platforms such as Alibaba or Taobao, the trademark owner could file a complaint with the operator of the online platforms, requesting for deletion of the product links. There are also some prior registered trademarks registered by others and used as domain names. In this way, the trademark owner could initiate a domain name complaint, domain name dispute resolution procedure to try to retrieve the domain name.
So generally speaking, we have two options when encountering infringements in China. That is filing a civil litigation at a local courts or filing an administrative complaint at the local administration for a rate action. Which way is better? Or can we say that the legal litigation has more advantages?
In civil litigation, the court could rule that the infringer bears civil liabilities, including stopping infringement, eliminating negative influences, and compensating to the trademark owner for the damages caused. It means that the trademark owner could have a chance to claim and obtain compensation through civil litigations. The damages for trademark infringement can be determined based on the actual losses suffered by the trademark owner. the profit acquired by the trademark infringer or a reasonable multiple of the royalties. The trademark owner could also request for punitive damages when the trademark infringement is committed in bad faith and is serious. The punitive damage could be up to 5 times of the amount determined in the above-mentioned ways. The trademark owner could also request for a statutory compensation up to RMB 5 million. The damages in trademark infringement will include reasonable expenses such as attorney fee, investigation fee, notarization fee rendered during the fighting against the trademark infringement. Another benefit of civil litigation is that the civil judgment will be published online and will be available to public. Therefore, it will have a strong warning and deterrent effect on the infringers. A supporting judgment will have positive influence on the different law enforcement authorities when trademark owner initiate trademark protection activities in future.
So we assume that civil litigation usually take about 2 years to go through the 2 years instant trial. In case the trademark owner wants to quick action to stop infringements, he may file administrative complaints with local competence administration. How about this procedure?
You're right. Administrative protection has high efficiency, as the redaction could be conducted within few days when the local administration accepts the complaint. The local administration could conduct on-site inspections and examine items relating to the infringement. If it is determined that the infringement is constituted, the local administration will order immediate cessation of the infringement. They will confiscate and destroy the infringing products as well as the tools used for manufacturing the infringing products. Besides, they will impose a mandatory punishment on the infringer, and the value of the punishment will be based on the value of the goods of the infringing products involved in the case. If the Trademark Infringement Act is suspected of constituting crime, the case would be timely transferred to judicial authority to pursue the infringer's criminal liabilities.
So how about the border protection? Can the Chinese customs stop exploitation of infringing and counterfeiting goods? How would you like to introduce us about this procedure?
Yes, the customs can stop the exportation or importation. China adopted custom protection on IP rights in 1995. The owners of trademark, patent, and copyright could have their IP rights recorded in the database of China General Administration of Customs. Take trademark, for example. Once the trademark has been successfully recorded, the trademark information will be shared by all local courts in China. During their routine inspections on imported or exported goods, if the customs officials suspect some goods might infringe a recorded trademark right, they will inform the trademark owner or the agent of the trademark owner based on the information recorded in the customs database. While the trademark owner shall reply to the customs within 3 workdays upon receipt of the notification. The customs, when they receive the application filed by the owner and remitted the required security bond, they will seize suspected infringing goods and proceed with further investigations. If the importer or the exporter could not submit document proving that the goods are authorized or genuine, the customs will confiscate the good and will impose mandatory punishment in the punishment decision.
So custom protection is really efficient and effective. How about online infringements? Online business develops rapidly nowadays in China, so trademark infringement can be found on different online platforms. How to stop infringement found on online platforms?
The infringing information found on online platforms could be used as lead to trace the infringer and to proceed with further legal actions against the infringer. Meanwhile, the trademark owners would like to stop the infringement found online as soon as possible. In this way, they could file a complaint with the operator of the online platforms, requesting for deletion of the infringing product links as soon as possible. For filing this kind of complaint, certain documents are required with a complaint letter. The documents will include, first, the copies of trademark registration certificates. Second, a company registration information of the trademark owner to prove the identity of the trademark owner. Third, links of the infringing products. Fourth, the reasons for determining that the products are counterfeit or infringing. And finally, if the complaint is filed by an agent, a POA is required. When the online platform receives the complaint, it will forward it to the counterparty. If the counterparty could not prove that the goods are genuine or with authorization, the product links will be deleted immediately.
So how about domain name protection? Could you tell us something about the domain name dispute resolution procedure?
The domain name dispute resolution procedure is a unique and efficient resolution procedure for solving dispute over registration and use of domain names. Complaint against domain names with different suffixes shall be filed with different resolution service providers. For example, domain name complaints against Chinese country-level domain names shall be filed with CIETAC, Online Dispute Solution Center, or Hong Kong International Arbitration Center. CNDRP is modeled upon UDRP, and it is the policy applicable to solve Chinese country-level domain name dispute.
If a CN domain name containing a client's registered trademark is registered and used by a third party, can it be retrieved through domain name dispute resolution?
Yes, it is possible to do so. However, it is necessary to first check and confirm certain facts before initiating a domain name complaint. According to CNDRP, complaints against the Chinese country-level domain names shall be filed within 3 years of the domain name registration date. Therefore, it is necessary for the trademark owner to first check the registration date of the disputed domain name, and then to confirm that the trademark is registered prior to the registration date of the domain name to guarantee that the domain name complaint meets the preliminary filing requirements.
Thank you. So the key takeaway here is to get trademark registration first in order to get adequate protection in China. We can choose either judicial or administrative way to protection according to our need. For both the protection, custom regulation is necessary.
Thank you very much for the insightful presentation, and I can see that we gain a lot of interest from our participants today. There are a lot of questions which we are going to address during this Q&A period. The first question is, may we know whether the list for subclass is available for public access in English?
Oh, yeah. We can check, we can search or identify the subclasses of goods and services, and also to check whether such goods and services are can be accepted by the CNIPA on the CNIPA's online database. However, the descriptions of the goods and services should be in Chinese characters.
The next question is, let me get it from the Q&A session first. Could you share the specific law regarding the bad faith prevention of 2019? I think he mean, from Mr. Warapon, I understand that you mean the name of the specific law about the bad faith prevention.
Yes, we can share the regulation to through Songbong. Maybe I send email to Songbong. Songbong can send the same to you. In English, the translation in English, yes.
Okay, perfect. Then let's go to the next question from Mr. Pisset. Can we invalidate the cited marks on the ground of bad faith? That's the first question. Or anything that we could do. The fact is, they know that our trademark has been registered in one class, but still having a registered trademark registered in another different class. So this is a situation where you have we have registered one trademark in one class, and then other parties try to register the same mark in other classes. What could we do? And can we invalidate the mark on the ground of bad faith?
Okay, I will answer this question. Regarding the bad faith, actually, it is a large, very general description, because there are several situations according to China trademark law will be considered as bad faith. For example, the applicant of the trademark filed many trademarks that are copies or imitations of others' trademarks, which we can be considered as bad faith. There are also other situations. For example, the applicant of the trademark once have business contacts with the real trademark owner of this trademark. So it will also be considered as bad faith. Regarding the specific situation, such as we have one trademark registered and the other party file the same trademark in other classes. Well, to prove the bad faith, we need to file evidence to show, for example, the applicant of the later mark once know your trademark, or the applicant of the prime mark, or if the applicant of the later mark file many trademarks that copies or imitations of others' trademarks. But if there's no such evidence to show the bad faith, I think the only argument that the later mark is just the same mark in other classes will not be considered as bad faith. Yeah.
Okay, pretty clear, thank you. The next question is, what trademark infringement acts are considered a crime under Chinese law?
Trademark infringement crime requires certain standards, such as you're using the registered trademark on identical products covered by your trademark registration, and the sales volume shall reach a certain standard. If I remember it correctly, it should be RMB 30,000 yuan or 50,000 yuan, and something like that. It's mainly about identical products and the value of the products that were already sold out. Okay, good.
The next question is pretty specific to the participants' companies. So PT-SIF, sorry if I mispronounced that. PT-SIF has already filed Indo Cafe first before others, but why when PT-SIF want to file another Indo Cafe's designs, CNIPA refused PT-SIF Indo Cafe mark based on the registration of other parties, even when PT-SIF filed Indo Cafe mark first. I understand that in this case, the company has already registered Indo Cafes already, and then for a while they filed for a revised trademark or some newer trademark, but still it encompass the word Indo Cafes, and then the latter has been rejected because of being similar to some other cited mark. Is it a usual standard at the CNIPA?
Well, I think maybe the new trademark application for Indo Cafe is not identical with the previous one, and you know, in China, the trademark examination is based on the principle of case by case. So, actually, if the trademark is refused based on similar trademarks that filed during the intervals of the previous INTA trademark and the later application of INTA, we can file review to argue that actually the same applicant has a very similar trademark containing INTA previously, but whether the such argument will be accepted will also determine if the similarity degree between the later filed INTA and the cited trademarks similar to INTA. Yeah.
I see. And the next question from the same attendees is, why is the word Indo always in question, but other party can successfully register Indo food that consists of the word Indo and food?
I understand your question. You mean actually Indo is the term Indo is always included in trademark applications, and so why it can be included in so many trademark applications, right?
Yes.
Yeah, actually, Indo. In our examples for Indo trademark, it is recognized that Indo has no fixed meaning. So I think it can be included in trademark applications, but you know, examiners may have different examination criteria. So for just as this example Indo trademark case, it was refused based on the grounds that Indo is misleading as to the origins of the goods. So I think we shall, if there is a specific case, we need to analyze case by case.
Okay, thank you very much. Next question is, can you please explain more about the criteria of well-known mark, well-known in the countries of origin, like for example, a Thai brand, if there are well-known in Thailand, is it qualified to get the well-known mark in China? Do we have to register to get the well-known trademark, or we have to get the well-known trademark by litigation?
Oh, no. Okay, I'll answer this question.
Please.
Yes. So for well-known trademark recognition and protection, there's no independent procedure for that thing, but we can claim for well-known trademark protection in one opposition, invalidation action, or litigation case. We need to submit evidence to prove that the trademark has been used in mainland China for at least 3 or 5 years and obtain very high reputation in China. So if for that Thailand brand you just mentioned, if it has been used in China and obtained very high reputation, it certainly has the possibility to be recognized and protected as a well-known trademark.
Okay, thank you very much. And may I clarify that a little bit? So it means that if the mark is a foreign well-known brand but has never been used in China, it will not be recognized as being a well-known trademark. Is that right?
I'm afraid so.
Okay, clear. Thank you. The next question is, in case of invalidation of bad faith registration, would chances of success be increased based on the number of trademarks filed by such registrants? I mean, like if the registrant has registered a lot of trademarks, I assume that the higher number of bad faith trademarks filed by one person would bring better chance of success since the bad faith intention is clear. From your experience, is there a minimum number of marks that could lead to invalidation more easily?
Well, actually, there's no limit of number how many bad faith filings by one applicant will be considered as bad faith. Usually, if there's solid evidence to show that the applications filed by the same applicant are indeed copies or imitations of others' trademarks, that fact will be taken into consideration by the CNIPA to consider such act as bad faith filing. So we cannot see how many numbers of applications will be considered. Yeah, it depends.
I see. Well, that's clear. Thank you. The next question would relate to counterfeit goods. So the question is, often the actual identities of the suppliers of counterfeit goods on online platform cannot be ascertained easily. Are there any procedures for brand owners to compel online platforms to reveal the actual identities of the suppliers so that the brand owners can pursue infringement action against the suppliers? In China, is it common for the online platform to be also named in any infringement action?
There are different online platforms, and for some online platforms, you can directly know the seller's identity. For example, on Alibaba.com or on 1688.com, you can directly see the sellers because the sellers are factories. They are B2B online platforms. But of course, as a client already found out, on other online platforms such as Taobao.com, you could not know the seller's name because Taobao.com is an C2C. It's meant to be an C2C online platform. The seller's information are under certain protection as privacy because they are individuals. If client could prove that the goods sold through Taobao.com are counterfeit, they could request Alibaba, because Taobao is also run by Alibaba, to reveal the real identity of the sellers. But client shall show some at least preliminary evidences proving how the counterfeit are judged. For example, through test purchase or through any other things the sellers may confess through chatting with the buyers that the goods are counterfeit. When clients has obtained preliminary evidences, they could write to Alibaba and request for revealing the identity of the sellers. If Alibaba or operator of Taobao refuse to do so, they would be listed as co-defendants in trademark infringement litigations. I hope I answered all
I see.
the.
Which means if they disclose thank you very much, and that's answer. But just to build on that, so if Alibaba and or Taobao disclose the name of suppliers or the name of the sellers, they would not be liable, and they will not be considered as being the defendant. Is that right?
Not really. Alibaba or Taobao should take necessary steps. For example, when you file the complaint and they immediately remove the infringing products, otherwise they will be considered as conducting the infringement together with the seller. But the right owner shall submit evidence proving there are counterfeits, because there are second-hand products on Taobao.com. So sometimes it would be difficult for Alibaba to judge whether the goods are genuine or counterfeit.
I see. Thank you. The next question is, to defend a non-use cancellation against a registered trademark, the evidence of use must be notarized or legalized in China. It appears to be difficult to organize such logistic evidence. I understand that the notarization and legalization will have to be done in the trademark applicant country. Is that it? The home countries, I mean. Okay. So I think I can take this. But to build on non-use cancellation, I also see in the chat box that there is another related questions about non-use cancellation. If we've got a non-use cancellation, but we have continuously renewed the trademark for the past 20, 30 years, but we have not used the mark in China, is the fact that the registrant has continuously renewed the mark considered to be some sort of justifiable reason for use?
No,
Okay.
it would not be sufficient. So regarding the document formality, we think it's better to submit the evidence in original or notarized and legalized versions so as to prove the authenticity of these documents. But in practice, in the notice cancellation procedure, usually it is not so strict with the document formality. But in the review on the notice cancellation procedure or the litigation procedure, we think the CNIPA and the court will be strict with the document formality. So we need to submit the original or notarized and legalized documents.
Understood. Thank you. The next question is, if our company has successfully registered our mark in one subclass, is it considered as infringement if we use our mark in other subclass with the main class?
I think that is related with the reputation of your trademark.
Okay, so the registration of the goods determine the protection scope of your trademark. If you register your trademark in one subclass, but use your trademark on the goods in other subclass, there is the risk of infringement in case other parties have prior registration or existing registrations for the same or similar trademarks on those goods in other subclasses.
I see. Thank you. So far, based on my own personal experience, this is the webinar that has been gaining the most questions so far. So that's exactly a good testament of your great presentation that draw a lot of attention from our participants. The next question is, if our trademark is partially refused against a few class, accordingly, we have to file an application for review against the refused classes. However, the IP office does not accept our application for review. Whether we may file appeal, if yes, how long does it take for the IP office to review and make a decision on our appeal? I'm not sure why the IP office does not accept application for review, but do you have any idea?
So I assume that the participant's question is regarding that in case the trademark is refused by the CNIPA, then he tried to review, and then the review is also rejected because the refusal grounds are not justified. Then we can further proceed. We have to appeal to Beijing IP courts. That's the administrative litigation, and then present our arguments and evidence to the courts. Then we may have the chance to overturn the decision of the CNIPA.
Okay, thank you. The next question is, if a registered trademark is facing a non-use cancellation by the registrant, okay, I think this is the one that I saw. Can they argue submit this to the CNIPA that the registrant has intention to use the mark in China in the futures? I don't think so, right? So the intention of use will not be considered in the non-use cancellations, right?
No.
Okay,
no.
Thank you. Next, can you please kindly advise who is the administration in the second remedies mentioned in part 3 on AMR? Thank you. What the name of the authorities or administration?
Market Supervision Administration.
Okay.
Market Supervision Administration.
It used to be administration administration for commerce and industry. Now it has been merged into the administration for market supervision.
Okay, thank you very much. Next, our trademark has been registered for more than 20 years in China. We refiled our trademark to prevent the 3 years non-use cancellation. Oh, that's smart. However, our trademark was refused by the registrar of CNIPA due to the prior registered trademark by a third parties. So in this case, I'm wondering why that mark can be registered together under the registration system while we cannot register, even if we are the first one who registered and our first trademark registration is still valid. Is it quite strange and seems like there is no standard. So what is your views on this? They seem to have a good strategies already.
Yes. Xiaoping. I will repeat your question that trademark has been registered for 20 years in China, right? So yes. Then the applicant tried to register the same trademark or similar trademark, but was refused based on a trademark filed by a third party, right? So the applicant is very confused why we have trademark applications previously, but the inserted mark can get registered, but our filing will be rejected based on the inserted mark. Well, I think the question is similar to the previous one regarding Indo Cafe trademark, and I think trademark applications, the CNIPA examine the trademark applications case by case. So we can file arguments or evidence to show that we have a previous registration and the inserted mark shall not get registered. But in the application for the later trademark, I think the most secured way is to tackle with the cited mark, that is the inserted mark by a third party. If the applicant thinks that the inserted mark shall not be registered because we have a previous similar trademark application registration, then we suggest the applicant file invalidations or other actions such as noise cancellation against the inserted mark, so as to eliminate obstacle for the later trademark application. Well, I think the only argument that we have a similar trademark previously may not be taken into consideration.
Yes, in case we have used our earlier registration in the markets, and we now, for the second time, we try to register the identical marks for the identical goods, and we can present to the courts showing that our use of the mark and possible argument about reputation of our mark in the markets, that it's likely that the courts will accept our request to register our mark again. But yes, I think it's a strategy, as mentioned by Xiaoping, that we can also take action against the later registration by the third party.
Yeah. Thank you very much. And yes, so a watch service would be really useful tools in managing your portfolios in China as well. Okay. So the next question has two big questions, but let me read the first question first. The first question is, the apply mark is refused on the ground that it contains the geographical name, which may mislead the public regarding the origin of goods. To overcome the citation, are there any possible suggestions in case the applicant cannot provide sufficient evidence of use in China? Can you also provide your estimate chances of success if no sufficient evidence of use are provided? I think we obviously before we can provide chance of success, we would we would need to know what is the trademark that we're talking about, right? But in terms of proving the prior use of the marks, I think the question would be that would the chance of success would be good if we cannot prove the use of in China when we face a citation?
Well, geographical name in China above the county level or the foreign geographic name that's well known to the public shall not be used as trademark according to the China trademark law. Actually, the geographic name shall not be used as trademark. That means even if the trademark has been put into use, the use evidence may not be taken into consideration to get the registration of the trademark. And there's an exception regarding this article, that is, if the geographic name in the trademark has other meanings, such as London fog. So the geographic name with other elements as a whole can be understood with other meaning other than geographic name meaning, so the trademark can get registered. Okay, thank you. And second question from the same participant, if an office action is issued on citations, on the other hand, the applicant are proceeding with non-use cancellation against the cited mark, and obviously the non-use cancellation would not have the final outcome by the deadline. Is it possible for the applicant to ask the IP office to hold off the case until the final result of the non-use cancellation is issued? If it's not, what is your suggestions to overcome this problem?
Yes, it's a very common issue in China now. Usually, according to our experience, the CNIPA is not willing to hold off the current review of refusal and wait for the result of the next cancellation. So our suggestion is that we file a review of refusal against the current application, and in the meantime file a backup new application as early as possible.
Okay, thank you very much. To give you guys a little bit of pause, I would like to reiterate that, first of all, we would, after this event, we will be sending the feedback surveys to all the participants. And in our feedback surveys, we will include the slide presentation of all speakers today. So that's the first thing. The second thing, the recording of the presentations by all speakers will be uploaded to YouTube channels under Tilleke Gibbins, so you would have access to look at our or to recheck the points that has been raised by our speakers on YouTube as well. Okay, the next question is, we have only other 4 questions to go. Hang in there. If one file a trademark application in one class covering more than one subclass, okay, and the application is rejected on grounds of confusingly similar with a registered trademark, can we delete the conflicting goods and request that the citation be removed without filing a review?
No, we need to file a review. We need to file a review of refusal, and in the review we can delete the conflicting goods and it's not allowed to just delete the conflicting goods and without filing a review.
Okay.
If the refused goods, if the conflicting goods are just the refused goods, such as the refusal is a partial refusal, so if the refused goods can be deleted, you accept the partial refusal, then it is not necessary to file a review, and we can just accept the partial refusal so that approved goods or services can get published.
Okay, understood. Thank you. The next question is, in regard to the mark that used for the herbal medicine, but that mark has not yet obtained the FDA in China. Is it because of the cancellation based on non-use, or will the mark abandoned by itself? So I think it's the case where they have registered herbal medicines, but the mark, because of the FDA issue, so the use cannot be commenced.
Yes, it can be a kind of a justified reason of non-use.
to defend against cancellation. Yes.
Okay, perfect. Thank you. Another question is, would you be able to share some example of the marks that have been recorded or recognized as a well-known trademark in China, which is not a Chinese characters, like the Rolls-Royce is the Chinese characters one, right? Do you have any idea of other English marks that has been recognized as a well-known brand in China?
Yes, actually, our firm successfully recognized many trademarks that are not in Chinese characters as well-known trademarks, such as Zara, Grandfos, Rolls-Royce, Nova Nordisk, and also
YKK,
YKK.
Puma, yes, a lot. And LG and Face Device, and also and also YKK for zippers. Yes, a lot. Actually, yeah.
Okay, thank you. Is it possible for when in a non-use cancellation procedures, does the petitioners who file the non-use cancellation could be anybody, right? Doesn't have to be any interested person, right?
Yes, can be anybody. Yeah.
Okay, perfect. Another question is, we read that some businesses have tried to use or file trademark application of Chinese Olympians' name, such as, sorry if I pronounce it wrong, Quan Hong Chan, after their successful feat in Tokyo recently. If a foreign athlete or celebrities who may not be considered public figures in China faces the same issue in China, what can they do to stop that? So this is tricky.
Okay, so I ever handled a case, a person in China try to register the name of the Schumacher, the famous car racer in China, and I represent Schumacher to file the opposition based on his prior name rights. So according to Article 32 of China trademark law, so prior rights such as a name rights can be protected against those preface hijackers.
Okay.
Yes. In case one applicant he tried to register a number of trademarks which is composed of famous foreign athletes' names, that kind of act can also be regarded as barefaced filing. So we can also request the trademark office to reject such applications based on Article 4 of China trademark law, namely the barefaced issue, barefaced article. Yeah.
Okay, perfect. Another three more questions. In Hong Kong, letter consents can be used automatically to waive citation. What about the situation in China? If we can secure letter consent, is it means that it will be automatically passed?
Yes, letter consent is also accepted in China in our practice. So if we can obtain the letter consent from the owner of the citing marks, and the two marks can be still different, they are not identical, then it's very likely the letter consent can help to waive the official refusal. But in case the two marks are identical, it's very likely that the letter consent will not be sufficient to waive the official refusal.
Okay. Well, thank you very much for this. Can I build on that a little bit? Is it possible for letter consent to be filed at the time of filing and fresh applications, so we can file it with examiners, or we have to file it with the CNIPA during the review procedures?
We have to file the letter consent during the review of a refusal. Yes.
Okay. Okay. Thank you. If company A has hired a Chinese factories producing their products, bearing their brands for selling only in Thailand, not in China, after that, company A found such factories has produced such goods bearing the company A brands without permission to sell in China. If company A only registers such trademark in Thailand, not in China, how the Thai companies could proceed any actions against such counterfeit goods selling in China? Well, this is another tricky question.
So the company A does not have any trademark right in China. It's
Yes.
only OEM production. And now company B is manufacturing and selling products bearing the specific trademark in China.
In China, yeah.
I'm afraid that company A could not do anything to stop such use because we generally only protected registered trademarks, and any registered trademarks shall obtain the well-known status through use. But as company A only manufacture the products and do OEM production in China, but do not sell the products in China. So it would be very difficult for company A to have its product have its run under production. So once company A decides to do OEM production in China, it shall consider the registration of the trademark in China.
I see. And they probably have to invalidate the registration of the company B's too, right?
Yeah.
Yes.
Okay. Good news. The next one is our last questions for today. For 3-year non-use cancellation, is that not applied to the available goods selling in China but not produced in China? So if the goods bearing that brand is on sales in China but not produced in China, is it okay?
Yes, it's okay.
Okay, so it can be used as a defense against non-use cancellations.
Yes.
Okay. Okay, I think we're done. Okay. So as a wrap up, we would like to again really thank you very much to all the speakers from CCPIT. This is the first joint collaboration between Tilleke Gibbins, CCPIT, and INTA, but obviously this is going to be the first among the other several futures webinars. So I hope that CCPIT team would also be hanging with us and will be open to our future collaboration on a similar project like this. Again, thank you very much, and thank you to all the participants today. As I mentioned, the slide will be sent to you later on with the feedback forms, as well as the YouTube session will be available at Tilleke Gibbins user. Feel free to subscribe on YouTube channel of Tilleke Gibbins so that you will be updated on any news about legislations or new practice in laws in Southeast Asia. So for today, thank you very much again to CCPIT team and all of you. Thank you very much and take care.
Thank you. Bye-bye.